What if the Guardian Ad Litem or attorney for child program that the courts administers is nothing more than a big money-making scam, just a way to pillage parents? What if? What if you could turn the whole thing upside down and stop it? Let's explore. Hello, my name is Jay Shore. I'm a certified Americans with Disabilities Act advocate. 28 CFR 35.101 says that the ADA is supposed to be broadly applied and construed to expansive uses to the maximum extent possible. And it's no secret that I've told that lawyers don't want to hold state courts accountable because it's a career suicide. They don't want to go in and sue a judge or a state court because they have to go to work in those courts and bring cases. So they're not going to hold these courts accountable. And that's something that I want to show you a thought form on. Understand this is absent intent or authority as legal advice. This is for education, entertainment, and information only. So I'm going to hit this. The following set of thoughts are presented only for education, entertainment, and information only, absent intent or authority as legal advice. Is the guardian ad litem or attorney for the child just a big money racket that the courts use to pillage parents out of astronomical fees? Axiom. An axiom is a self-evident statement. The legal definition of, quote, legal disability, end quote, in legal doctrine is summarized as a person under 18 or mentally incompetent. Axiom. The court appoints a guardian ad litem for the purpose of mitigating the legal disability of the state of being a minor. The legal disability of minority, the state of being a minor, is a physical and or mental impairment, state of being a minor, 28 CFR 35.108A, that substantially limits one or more major life activities. The major life activities substantially impaired by the legal disability of a minor are caring for oneself, eating, sleeping, learning, concentrating, thinking, communicating, interacting with others, and working. Other major life activities substantially limited are the operation of many of the major bodily functions which are still developing through childhood and adolescence. The legal disability of a minor is a physiological condition that affects one or more body systems. The medical community has even designated special doctors for minors called pediatricians because their body systems are developing and substantially limited from being an adult or of age of majority. The term substantially limits shall be construed broadly in favor of expansive coverage to the maximum extent permitted by the terms of the ADA. Substantially limits is not meant to be a demanding standard. 28 CFR 35.108D11. Axiom. The appointment of a guardian ad litem or attorney for the child, GAL, is a mitigator for the legal disability of a minor. The courts demand that the parents pay for the services of the court-appointed GAL. Since the GAL is appointed to accommodate or mitigate the legal disability of a minor, the court's demand for the parents to cover this charge for this accommodation seems to violate 28 CFR 35.130F, which states, a public entity may not place a surcharge on a particular individual with a disability or any group of individuals with disabilities to cover the cost of measures such as the provision of auxiliary aids or program accessibility that are required to provide that individual or group with the non-discriminatory treatment required by the Act or this part. Children are legally disabled individuals that need access to the courts, and because of their legal disability of a minor, they are appointed lawyers by the court. The court is surcharging this accommodation and forcing parents to pay for it. There appears to be no case of first impression on the appellate level or federal district court levels that assert that the legal disability of a minor is a disability that qualifies under the ADA, and thus the appointment of a guardian ad litem for the child cannot be surcharged by the courts. If all of the foregoing is true, the court's pillage of parents from the guardian ad litem system could end by bringing a case that A, claims the legal disability of a minor as a disability under the ADA as shown above, B, claims that the appointment of a guardian ad litem or child lawyer is solely for the purpose of accommodating/mitigating that legal disability of a minor, C, claims that the courts in appointing this accommodation is unlawfully surcharging parents for their children to have access to the courts as a disabled minor, and D, seeks the appropriate relief of reimbursement for every single guardian ad litem fee that the courts have forced parents to pay over the years. Just food for thought.